Now turn to the next case on this morning's docket. That is case number 104245, State of Kansas v. Francis Smith.
May it please the Court, Meryl Carver-Allman, Capital Appellate Defender, on behalf of Mr. Smith, and if I could please have 3 minutes for rebuttal.
3 minutes is granted.
I just want to start by, I know Justice Nuss was signing the order, so I'm sure he's aware. I don't know how much the Court is aware. The record in this case was a beast to put together, and I just wanted to, on the record, thank opposing counsel, because if she hadn't been helping to get it together, the court reporter literally disappeared with the transcripts. I don't think we'd be here today. So I want to say that first. Second, I want to offer the court maybe a little roadmap. This case has been buffeted quite a bit by changing case law. I think live issues that we have to talk about today are issues 1 and 2. I don't intend to argue issue 3. I think issue 4, the state is conceding, I believe from their brief, that there was a sentencing error. For my part, I concede that it makes no difference to my client's sentence. I believe the state's conceding 5 and 6, and I would concede that issue 7 has been decided by subsequent case law.
But how can you apply harmless error to an illegal sentence? If a sentence is illegal, it's void, and you know, I don't know how you say, well, it's harmless.
Well, and I certainly think if they want to go back and have resentencing on it, I would applaud that. I am in favor of correct sentences for everyone. I'm just saying that it's not going to make a difference. Ultimately, my client has a hard...
But we have an independent duty to look at jurisdiction. And if something is void, then we don't have... If there wasn't jurisdiction, we have to do something with it. We can't just say no harm, no foul, can we?
Well, and in that case, I would ask that the court remand it for resentencing, and that's absolutely proper. I'm just saying that for the purposes of our argument today, I think the real issues that we have to talk about are issues 1 and 2. And to kind of build on what Mr. Call has already said, I agree basically word for word with what he said about how I believe 6455, the analysis has changed with the new statute. In this case, it's a little bit... it's complicated because the judge actually says, I'm admitting this under the new 6455, but then he analyzes it just as if he's analyzing it under 455B, so allowing it in specifically for motive and intent. I don't know that matters just because of the way this court has construed the harmless error in cases. So, for instance, if there is a mistake and something gets in, you know, even if it was wrong for the judge to admit it under 6455B in my case, I think I still have to show that it wouldn't have come in under 6455D. Otherwise, I believe that you'll probably just say in your opinion, well, if we sent this back, it would come in anyway. So it sort of becomes a harmless error problem at that point. So I think really, although the district court analyzed it, I think, incorrectly under 455B, I think what we're really talking about is, as the state says in their brief, 455D here. And I agree with what Mr. Cole said. Basically, I think just the materiality element comes out, and then we're talking relevance, and we're talking prejudice versus probative. In the brief on issue 1, and that's the prior convictions, I believe I admitted that the prior convictions were relevant to show intent, and I think that that's still true. My client got up. He testified. It's not even a full page of testimony, I believe, and he admitted to taking the photos in this case, but said that it wasn't for a sexual purpose. It was just the girls were going to be apart for summer vacation, and they wanted some pictures of each other. So I think that the priors probably are relevant as to his intent. Now, when you get to the prejudicial versus probative weighing test, I think is where the state gets into problems with this issue. Here, again, looking at the similarities between the convictions, which, as Mr. Call argued, I think that's still important. The prior convictions in this case were 15 years old. Also, there's very little in the record here. We know that the prior convictions were a rape, 2 counts of aggravated indecent liberties, I believe, and 1 count of aggravated criminal sodomy. So we have, in that case, I guess we can assume from those facts, penetration of some sort, certainly from the rape, and that's just not the case here. I think the crimes in this case, I don't want to say they were trivial in comparison, but certainly there was no penetration in this case. So that is how I would argue that they are different, and therefore the priors were more prejudicial than probative. Moving on to issue 2, which is, I think, really related. And issue 2 was not a 455 issue. It was just sort of more a straight relevancy issue. And that was pictures of basically stacks of pornography that were found in Mr. Smith's house. Legal pornography. It wasn't underage pornography. Were admitted at the trial. And again, it was to show purportedly Mr. Smith's intent. And again, I think you have to look at the similarity of the pornography to the crimes charged. If you look at the exhibits, the pornography that was shown was very graphic. It was unclothed girls. It was much more hardcore, if you will. Whereas the pictures that Mr. Smith admitted to taking in this case, by comparison, and I've been struggling to think of the right word to describe them, but by comparison, they're almost Halloween-y, or I guess the girls are sort of in like warrior princess costumes, and they're just not of the same level. They're almost silly, sort of, by comparison to this more hardcore pornography that was found in Mr. Smith's house. But if you look at the prejudicial effect of that pornography, I think there are a lot of places in the world, and I think a lot of places in Kansas still, where just having pornography makes you a bad person in the eyes of people who would be on a jury. And so I think that the prejudicial effect of that can't really be overstated. And so we would argue that it outweighed the probative effect. I think that would conclude my presentation. I'd be happy to take questions from the court. Justice Lukert, I don't know if you wanted to ask. I don't know if you were intending to ask me about the Boline case. I am familiar with it if you have a question about it, but...
I actually will ask the state how that impacts their argument, so...
Okay.
I was looking ahead to this case, obviously.
Any further questions of counsel? Thank you, counsel.
Thank you.
Good morning. May it please the court, my name is Terry Johnson. I'm Bourbon County Attorney representing the state of Kansas. And I will focus on the first 2 issues. And Justice Eager, I don't know whether you want to just jump right into the pornography
Just a word so as you get to that.
Okay.
If you will.
The judge did, in the 6455 issue, acknowledge that we were under the new statute. And counsel is correct. We still did the analysis under the old statute. So the judge was very cautious, and frankly, I think all the parties were very cautious. We weren't sure what we were doing. The issue in this case was Mr. Smith gave innocent explanations. He first denied taking the pictures at all. Then he said the pictures were consensual. He said he wasn't aroused because he was gay. He liked he/she's, which he defined as men with penises, or women with penises. He claimed he wasn't aroused.
But the actual charges here that we've got, he's charged with touching.
Right.
With not taking the photos.
Right.
I mean the photos, taking the photos, but changing their positions and changing their clothing was what formed the act of indecent liberties. And so I think we need to keep that in mind instead of just talking about taking pictures. It's not that taking the pictures that forms the basis of this crime. And so we need to relate that to what he was actually doing.
That is true. And however, when he talked about taking the pictures, one of the things we have to prove is that his intent in taking the pictures. And he testified at trial. He wasn't aroused.
I'm losing you there. If he was taking those pictures to use later for his gratification, would that form the basis of the crime with which he was convicted?
I understand your question. No, it would not, because he was convicted of actually posing the girls.
Touching, of the actual touching.
Right, of the posing them in the course of taking the pictures. So I think taking the pictures is relevant because that's how he had the opportunity to pose them.
Well,
But
tell me if I'm wrong. In order to convict, the jury had to find that when he touched the girls to change their position or to pull up their bikini bottoms, that actual touching was done with the intent to gratify his own sexual desires, not the fact that he's taken pictures of young girls in bikinis.
that is correct.
Yeah.
That is correct. Lost my train of thought here, but
I'm sorry.
that's okay. That is correct.
So we're
But-
talking about motive and intent. How does that relate to the touching?
Well, what he talked about was that he testified he was not aroused. Now, I'm going to add that, and you'll probably stop me, but I'm going to add when he was taking the pictures. But the evidence was clear that when he was taking those pictures, he was touching those girls. But he placed his intent, and counsel for Mr. Smith admits intent was an issue, the intent to arouse. So that would be my argument.
Let's move to the next step with regard to the pornography
Okay.
and the relevancy there with regard to the actual touching. Not the fact that he's taking pictures, but the touching. How is the pornography relevant to the purpose with which he touched the girls?
Okay. He denied initially touching the girls. He said he didn't like girls. He said he was gay. He then said the photos, that again, the touching was done during the photos being taken, was consensual. So when the officers found the photograph, or found the magazines, and they did not collect the magazines. The jury didn't have the magazines to leaf through. They took pictures of the front cover of the magazines. They testify it was partially nude. Girls, you've got the pictures that were admitted. Some of them were not nude. And so since he said he did not like girls, he wasn't aroused, he did not like girls, I think it is relevant and
On credibility. On
relevant
credibility.
and material. What?
On credibility.
On credibility,
Oh, that was going to be my question.
yeah.
And how
And
does
it's not
that
just
prove?
credibility, but it also would be substantively relevant. Is that right? Because it's going to whether he had the intent.
That's correct, to arouse. And Justice Lugar, I am sorry, I am not familiar with that case. If you want to
Well,
make me familiar
in that
with it.
case, we said the fact that the defendant possessed pornography depicting homosexual acts was not evidence, was not relevant to whether the defendant was gay or not. And here you're saying that pornography showing females is relevant to establish that the defendant here was not gay, that he was lying. So it's a little difficult.
Well, and, if the issue, he was saying I couldn't have taken those photographs, therefore touching the girls, because I'm gay. So he was setting that up, and so I do think they were relevant to show
But what
he
we're
wasn't.
talking about is, why does a person that has pornography in the closet, how does that establish their sexual orientation? I think that's basically what we said in Boleen, is that that's not evidence of sexual orientation.
But was in Boleen, I kind of do remember this case, was the issue that he was gay and a significant issue to the actual
It was his
facts in the
defense.
case?
It's his defense, yeah.
Right,
It was his defense.
right.
That he did not, so yes, it was core. It was a central issue.
And so I think it's a little different here. I mean, it is his first statement to law enforcement. I didn't take these pictures. I'm gay. I don't like girls. And then coupled with, yeah, I took the pictures, but I wasn't sexually aroused. And we had to prove that he did this for the purpose of sexual arousement. So I think they were relevant and probative.
Did you have any evidence from any other source that a person who has pictures of women in their closets therefore must not be gay?
I do not present any other evidence of that. Does the court have any further questions?
The first issue, the evidence of the prior crime, I think you said this was kind of a combination case. You did have the new statute, but the judge kind of went back and looked at some of the factors in the old. But from your vantage point as a prosecutor, why were you introducing that evidence? What was it relevant to?
We were introducing in my 6455 motion was on intent and motive. And my recollection is we did have some discussion regarding propensity, but that was not, my 6455 motion was specific on intent and motive. And I also agree with the prior arguments. I don't see anything in the new 6455 statute that requires the court to analyze whether the crimes were similar or not. I think that if this court required that, then I don't understand the need for, or why the statute was changed.
Did
You understand
Sorry.
what
I was going to move to a slightly different area, but if
Okay.
you're directly on point, go
I
ahead.
think the point in the previous argument was that even though similarity does not need to be evaluated anymore in terms of admissibility on the relevance piece, it still needs to be looked at on whether the evidence is probative when you do the probative versus prejudicial weighing.
I think it can be looked at, but I don't think it should be a bar if they're, I mean, it seemed like the argument was if they're not similar, it's not probative.
Well, but I see that the age impacts whether it shows propensity. If you take the fact or you take the concept that people that do this do it on a chronic basis, the fact that something happened in 1997 sort of refutes why haven't they done it in between time, or maybe they just didn't get caught, but still that age would impact whether there really is a propensity to do this, wouldn't it?
I don't know if it would. I guess you would have to look at the situation. If someone, for example, committed this act in 1997 and was in prison for 20 years, it would be different than the instance we had, the last argument, where they were diverted, which would be imply that they weren't in prison. So I just think that I think it can be part of the analysis and probably should be part of the analysis.
And how probative it is.
Right.
I'm just going to ask, did you make a harmlessness argument in this case?
I believe I did.
Okay.
I can look real quickly.
And, well, I'll look through your briefs again. Thank you.
I did. I made a harmless error argument.
And
Was that
having
on, sorry, was that on the cumulative error argument, or was that on some of the specific issues here?
No, that was on the 6455 issue.
And what about the pornography issue?
The what? I'm sorry.
The pornography
Let me
issue.
look at that.
Well, we can find that. Let me see if I can,
It does not look like I did on the pornography issue.
Councilor Johnson?
Yeah, back to my question earlier, what I'm seeing on the harmless argument is this overwhelming evidence that he took pictures and of these girls. He had, rather than the overwhelming evidence that he says he moved them around to pose them for the pictures. Your allegation is that he touched them for self-gratification. And so what is the overwhelming evidence that touching was not posing, as he says, but an aggravated indecent liberties touching?
Well, it would be the girl's testimony is what it would be. The two girls' testimony, both of them consistently said what he did and how he posed them and how he moved them and touched them. Again, and I realize and I understand that the taking of the photos, he wasn't charged with taking the photos, but the two were linked. You can't, he didn't just touch them, he touched them during taking the photos.
Let me ask you, so any photographer, professional photographer, amateur photographer, who takes a picture of an underage child or underage person in a sexually provocative pose and manipulates them or touches them in getting them in the right pose, which I think we see plenty of those. In every magazine that's out there today is committing indecent liberties with a child.
No.
Is that what we're looking at here?
No, I don't think
Why
that's
not?
what you're looking at. Additional testimony, and I believe I have in my brief, is the things that he said during the time that he was touching, particularly HD. That he told her he loved her. That he told her next time we'll do photos without tops on. That he, and I apologize, I know it's in my brief, but there were things that he said specifically with her that he asked the two girls to kiss, and he positioned them on how to kiss. So I think it's not just the photos themselves, but his actions in taking those photos. Does anyone have any additional questions?
Just to clarify your answer to Justice Johnson's question, your argument that the error was harmless on 455 is that there was other evidence, and that was provided by the victims in the case.
That is
their
correct.
testimony.
And there was evidence, for example, the photos were taken with a Polaroid. We found the Polaroid. The girls said they were taken with a Polaroid. They said they were taken in a specific room in the house. He admits they were taken in that specific room. So, I mean, there was corroboration of their testimony also. So yes.
Any other questions of council? Thank you, council.
Thank you.
If the court has questions, I'd be happy to answer them. Otherwise, I'll waive rebuttal.
Well, just to clarify, you did not raise insufficiency of the evidence to support the charge.
I did not, and maybe I should have. I honestly, in reviewing this case, did not foresee a world where that would fly, but maybe I was mistaken there.
Okay, I just clarify, and we don't have any challenge to the length of sentence or anything like that.
No, not in this case.
Any other questions of council? Thank you, council.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.